The Committee of Finance is hereby called to order. Madam Clerk, may I have a roll call, please?
Senator Marvin A. Blyden. Senator Blyden, present. Senator Samuel Carrion. Senator Carrion, present. Senator Dwayne M. DeGraff. Senator DeGraff, present. Senator Donna A. Fred Gregory. Senator Fred Gregory, present. Senator Javon E. James Sr. Senator James Sr., present. Senator Janelle K. Sarow. Senator Sarow, absent. Senator Kurt A. Vialet.
Here.
Senator Vialet, present. Mr. Chair, you have 6 present, 1 absent.
Thank you, Madam Clerk. Any correspondence?
No, Mr. Chair.
Thank you, Madam Clerk. I want to thank Senator Noble Francis. I also welcome Senator Francis for being here and mark Senator Sarow as present. So we have a full complement. So good morning to the people of the Virgin Islands. Good morning, colleagues. Good morning to the testifiers. Madam Clerk, may you proceed and read the agenda into the record.
The Committee on Finance for Tuesday, March 15th, 2022, in the Fritz E. Lewetz Legislative Conference Room, Christiansted, St. Croix, U.S. Virgin Islands. The Committee on Finance will consider the following bills. Bill number 34-0191, an act amending Title 22 Virgin Islands Code, Chapter 55, relating to captive insurance companies to clarify the purpose of the chapter and to prohibit the organization within the Virgin Islands of a special category of multi-state insurers that may not be required to comply with the accreditation standards established by the National Association of Insurance Commissioners and adopted by the territory as a NAIC accredited jurisdiction, proposed by Senator Donna A. Fred Gregory. Invited testifier, Glendina P. Matthew Esquire, Acting Director, Office of the Lieutenant Governor. Bill number 34-0204, an act amending the Virgin Islands Code, Title 22, Chapter 58, relating to self-insurance, and Title 29, Chapter 10, Section 543, relating to the powers of the Port Authority to authorize the Virgin Islands Port Authority to establish a self-insurance program to cover and manage certain risks. Proposed by Senator Kurt A. Vialet. Invited testifiers, Carlton Dow, Executive Director, Virgin Islands Port Authority. Glendina P. Matthew Esquire, Acting Director, Office of the Lieutenant Governor. Mr. Chair, this concludes the reading of today's agenda.
Thank you, Madam Clerk. Colleagues, we have an easy day today, just 2 measures. So I think we'll have a very easy and early day. The first bill number 34-0191. Who speaks to this bill? Senator Donna Fred Gregory, you recognize.
Thank you, Mr. Chair. Good morning, colleagues. Good morning to the listening and viewing audience, and good morning to the testifiers. This morning, I offer Bill number 34-0191 by request of the Governor. Bill number 34-0191, an act amending Title 22, Virgin Islands Code, Chapter 55, relating to captive insurance. The bill seeks to define and clarify the purpose of the chapter to limit any insurers other than multi-state insurers from being licensed as captive insurance under this chapter. Multi-state insurers may only be licensed in the territory as captive insurers, which will be subject to the accreditation standards of the NAIC. With these safeguards in place, the measure will strengthen the regulatory oversight of the Division of Banking and Insurance over the captive insurance program and secure reaccreditation of the Division of Banking and Insurance. The legal counsel of the Division of Banking and Insurance identified some concerns, as well as the legislature's legal counsel with the bill, and an amendment will be brought and filed in the Committee on Rules as we traverse the landscape of this significant piece of legislation. Thank you, Mr. Chair, for the time.
Thank you, Senator Fred Gregory. Attorney Matthew, I'll give you a chance to put your name on the record, and also the two individuals who are here with you. And what a difference to be back live and watching you. Today's a good feeling. First finance meeting in a while that we're back live. So you may put your name on the record.
Good morning, Attorney Glendina Matthew, Acting Director for the Division of Banking, Insurance, and Financial Regulation under the Office of Lieutenant Governor.
Next, Counsel.
Good morning, Suzette Richards, Legal Counsel for the Division of Banking, Insurance, and Financial Regulation in the Office of the Lieutenant Governor.
Thank you. Next.
Good morning, Ashton Bertrand, Chief Order Financial Services, Division of Banking, Insurance, Financial Regulation in the Office of Lieutenant Governor.
Thank you so much. You may proceed with your testimony.
Good morning, committee. Good morning, Chairman Honorable Kurt A. Viale, and honorable members of the 34th Legislature of the Virgin Islands, Committee on Finance, other senators present today, as well as a viewing and listening audience. I am Glendina Matthew, Interim Director of the Division of Banking, Insurance, and Financial Regulation within the Office of Lieutenant Governor and Commissioner of Insurance, the Honorable Tregenza A. Roach, Esquire. I most respectfully appear before you today to provide testimony on Bill number 34-0191, an act to amend Title 22, Chapter 55 of the Virgin Islands Code by clarifying the purpose of the chapter so as to prohibit the organization within the U.S. Virgin Islands of a special category of multi-state insurers that may not be required to comply with the accreditation standards established by the National Association of Insurance Commissioners, NAIC, and adopted by the territory as a NAIC accreditation jurisdiction. I am accompanied by Attorney Suzette Richards, the division's legal counsel, Attorney Dolis McLean, legal counsel for the Lieutenant Governor, and General Counsel for the entire Lieutenant Governor's Office, and Mr. Ashton Bertrand, the division's Chief of Other Financial Services. We most respectfully inform you that the Office of Lieutenant Governor, Division of Banking, Insurance, and Financial Regulation fully supports Bill number 34-0191 with some additional amendments. The bill as currently drafted aims to, among other things, change the name of the Title 22, Chapter 55 of the Virgin Islands Code, currently known as Virgin Islands International Insurers Act, to Virgin Islands Captive Insurers Act. Strike any reference to the term international insurers and insert in its place captive insurers wherever it appears in Chapter 55 of Title 22 Virgin Islands Code. Clearly define what is a captive insurer, which is an insurance company created and wholly owned by one or more non-insurance companies to insure the risk of its owner and parent corporation, essentially a form of self-insurance, whereby the insurer is owned wholly by the insured and typically established to meet the risk management needs of its owners or members, and whose primary jurisdiction is known as its domicile. Clearly establish the purpose of the chapter, which is to allow for the statutory organization of a captive insurance company, which may be classified as any single-parent captive insurance company, association captive insurance company, or industrial insured captive insurance company, or any branch exempt captive insurer licensed under the provisions of this chapter to underwrite risk situated exclusively outside of the Virgin Islands. Prohibit the licensure of international insurers under the captive program, and prohibit a captive insurer from converting to or being licensed in its jurisdiction as a traditional multi-state insurer. I will begin my presentation by explaining further what a captive insurer, also known as a captive insurance company, is, and common reasons for its formation. As defined in Section 1401 of this bill, a captive insurer is essentially an insurance company created and wholly owned by one or more non-insurance companies to insure the risk of its owner or parent corporation. A captive insurance company may be formed if the parent company cannot find an insurer to insure them against particular business risk, if the premium paid to the captive insurer creates tax savings, if the insurer provided is more affordable, or if it offers better coverage for the parent company's risk. The new definition of captive insurer in this bill aims to not only classify the different types of captive insurers that may be organized in the territory as provided in Section 1401T of Title 22 Virgin Island Code, but to clearly define what a captive insurer is. It should be noted from the outset, unlike traditional self-insured entities that are generally not a licensed insurance entity, captive insurers and branch captives are licensed in the U.S. Virgin Islands and cannot underwrite its own risk situated in the territory. I emphasize that. Cannot underwrite its own risk situated in the territory. Captives in the territory may only underwrite risks situated exclusively outside of the Virgin Islands pursuant to Section 1401T. By way of background, the Virgin Islands Captive Insurance Program was first established by Act Number 4900 and codified in Title 22, Chapter 55 on March 7, 1984. Since then, Act Number 4900, followed by Act Number 7025, the Alternative Market and International Reinsurance Act, as codified in Title 22, Chapter 54, were repealed. Act Number 7569, the Virgin Islands International Insurers Act, as codified in Title 22, Chapter 4 and 55 of the Virgin Islands Code, is one of two acts governing the Virgin Islands Captive Insurance Program. Chapter 4 of the Act created within the Office of Lieutenant Governor the Division of Alternative Market and International Reinsurance, and granted the Superintendent of Alternative Market, also known as a SAM, the authority to license and regulate captive insurers and the Alternative Market Program under Chapter 55 and 66 and applicable rules and regulations, respectively. Chapter 55 of this Act created the requirements for the licensure and regulation of traditional captive insurers, including Protective Cell. And Chapter 66, also known as the Alternative Market Act, created a framework for the licensure and regulation of alternative securitization insurance entities, which are entities formed under this chapter that purchases portfolio of assets and uses debt obligations and other legal form to transact business. Besides the licensure and regulation of captive insurance program under Title 22, pursuant to Title 13, Chapter 14 of the Virgin Islands Code, any captive insurer seeking a tax-exempt company status was required to apply to the division for a certificate for an exempt status and tax incentive benefits. Why is Bill number 34-019 important? As this legislative body is aware, prior to the division becoming accredited for the full 5-year period by the NAIC in December 2021, The division was conditionally accredited in December 2019, subject to a 2-year review. To achieve full accreditation, the division had to endure a series of reviews to demonstrate to the accreditation review team that the division had enacted the required NAIC model laws, and the division was conducting its examination analyses of its domestic insurance companies in accordance with the NAIC standards, meaning that the division was required to prove to the NAIC all domestic multi-state insurers are subjected to the same baseline standards. Any appearance that the division has created a category of multi-state insurers not subject to the accreditation standards could result in the division losing its accredited status. The division would like to again thank this legislature for their enactment of the required NAIC model laws and the staff for their hard work in the regulatory oversight of our domestic companies, which enabled the division to become accredited. However, we are reminded that accreditation of the division is only for a 5-year period. Every 5 years, a review team will perform an on-site review and assessment of the division to determine, 1, if the required NAIC model laws are in place, and 2, if the division continues to maintain the baseline standards. The division's next accreditation review will be conducted in year 2024. As discussed before, the purpose of the NAIC accreditation program is to develop and maintain standards to promote effective insurance company financial solvency regulation. All accredited states are required to maintain a baseline level of effective financial oversight of its domestic multi-state companies. This is particularly important since non-domestic states rely on accredited domestic states to apply the appropriate NAIC standards in the regulation of multi-state insurers. The failure of a state to maintain the NAIC standards may result in the state accreditation being suspended. During the accreditation review process, the NAIC raised a few concerns. One of the issues raised was whether Title 22, Chapter 55 of the Virgin Islands Code, currently known as the Virgin Islands International Insurers Act, allows for the organization of a special category of multi-state insurers, which may not be subject to the NAIC accreditation standard. The NAIC raised this issue when it learned the term international insurer was being used by another jurisdiction to create a special category of insurers that were not subject to the NAIC accreditation standard. Whenever the NAIC investigates issues that relate to accreditation, that information is kept confidential and the jurisdiction is not identified. In its review of our insurance code, the NAIC noted Title 22 of the Virgin Islands Code also had an insurance licensing category called international insurers. We impressed upon the NAIC in several correspondence that the term international insurer or international insurance company, as used in the Virgin Islands Code, has traditionally been used in the context of the Virgin Islands Captive Insurance Program. And the term international insurer or international insurance company is synonymous with the term captive insurer or captive insurance company. Notwithstanding, as the usage of the term international insurer or international insurance company in the territory's captive law has created some confusion in the industry, this bill seeks to address the concerns noted by the NAIC by changing the name of Title 22, Chapter 55 of the Virgin Islands Captive Insurers Act, stating clearly the purpose of the chapter, Chapter 55, defining what a captive insurer is, and ensuring anywhere where international insurer or international insurance company appears in the Virgin Islands Code, including Title 22, Chapter 4, Chapter 55, and Chapter 66, and Title 13, Chapter 14, the term is deleted, and the term captive insurer or captive insurance company is inserted in its place, respectively, and also deleting the term international in the terms cited in subsection D below. The division believes that there is a need for additional language for the intent of the bill to be clearly understood. As such, to fully effectuate the purpose of the bill, the following suggested amendments are also needed. Section 1 should read, the Virgin Islands Code Title 22, Chapter 4, Chapter 55, and 66, and Title 13, Chapter 14 are amended in the following instances. On page 3, line 11, insert an international insurance company or international insurance companies after international insurers and before, as the case may be. On page 3, line 12, insert an captive insurance company or captive insurance companies after captive insurer and before as appropriate. The amendment should read as follows. The term international insurer or international insurers, an international insurance company or international insurance companies, as the case may be, are stricken wherever they appear in the chapters, and captive insurer or captive insurers and captive insurance company or captive insurance companies as appropriate inserted in its place. On page 3, line 15, the definition of captive insurer is amended by inserting after captive and before means, also known as captive insurance company. The definition of international insurance company as defined by Title 22, Chapter 55, 1401T is deleted. Any reference to title exempt international insurer, any reference to exempt international company or exempt international companies, an exempt international insurer or exempt international insurers, branch exempt international insurer or branch exempt international insurers, an international reinsurer or international reinsurers, an international reinsurance, an international reinsurance business or international reinsurance businesses, an international support business or international support businesses, an international insurer support business or international support businesses in Chapter 4, Chapter 55, and Chapter 66 of Title 22 of the Virgin Islands Code, and Chapter 14 of Title 13 Virgin Islands Code should be stricken. An exempt captive company or exempt captive companies, an exempt captive insurer or exempt captive insurers, branch exempt captive insurer or branch exempt captive insurers, and captive reinsurer or captive reinsurers, and captive reinsurance and captive reinsurance business or captive reinsurance businesses, and captive support business or captive support businesses, and captive insurer support business or captive insurer support business inserted in its place, respectively. Chairman, Honorable Kurt A. Vielle, and members of the committee and other senators present, this concludes my testimony on Bill number 34-0191. We thank you and the members of this committee on finance for the opportunity to appear before you. Moreover, we greatly appreciate your support of our endeavors to continue to update Title 22 of the Virgin Islands Code, commonly known as the Virgin Islands Insurance Code. We are prepared to respond to your questions on this bill. Thank you.
Thank you for your testimony. And the bill is kind of straightforward because it's just really deleting international and replacing it with captive. So we're going to go to a 3-minute round, colleagues. I think that should be sufficient, and we'll start with Senator Blyden.
Thank you so much, Mr. Chair. Good morning to my colleagues, viewer and listening audiences, staff, central staff. Good morning to the testifiers, and Attorney Matthews, thank you so much for that testimony. Testimony was clear and point, and I understand exactly what the intent to include the amendment. Basically, it's clarifying the definition. It addresses the NAIC concerns to include the industry, to clear up confusion, as you stated, and assure that Title 22 of the Virgin Islands Code is clear. So let me ask you another question in respect to the captive insurance. Is that a type of self-insurance? Can you clarify for me?
It is a type of self-insurance. However, there are limitations as it relates to captive insurer. A captive insurer is usually one based on Title 22, Section 1401, in the entity that is providing captive insurance cannot underwrite its own business in the territory. A captive insurance, the whole purpose of a captive insurance is that companies, parent companies, as well as their affiliates, they're able to underwrite their own risk for the business. So in cases like, for instance, where someone may have liability requesting or wanting liability insurance, they can underwrite their own risk of the parent companies or their affiliate companies.
And that's why you emphasize the risk, but outside of the territory.
Correct.
That's the critical part right there.
1 minute.
Okay, well, thank you so much for your responses, Mr. Chair. I have no more questions. Thank you so much for your testimony.
Thank you, Senator Blyden. I also want to welcome Senator Carla Joseph. Thank you for coming. Senator DeGraff, you recognize.
Good morning, colleagues. Good morning, testifiers, all viewing, listening, and present. So we're changing the name International to Captive, and the intent of it and definition, the definition is different, but is the intent of what's already in the bill, the law, the same?
The intent of captive insurance remains the same as it was previously written in Title 22. However, because of the term that's being used, this is where what created the confusion, the term international insurer. But the intent of the bill as it is in the Virgin Islands Code remains the same. In the Virgin Islands Code, you see the word international insurer associated with describing a captive, saying it's an association captive, it's describing different type of captives. However, there wasn't a clear definition stated in the Title 22. However, this bill seeks to not only describe what a captive, the different type of captives, but also include the definition of captive.
Okay, and
Insurer.
finally, captives in the territory may only underwrite risks situated exclusively outside the Virgin Islands pursuant to Section 1401T.
Correct.
Give me an example of what a captive insurance company is, or what is one? Who is one?
There are a lot of captives that are currently licensed in the Virgin Islands.
Yeah, name one. Yeah, you could name one. You said.
Yeah, UPINSCO would be one.
I didn't understand what you said.
UPINSCO would be a name of a captive that was licensed with us previously.
1
and
minute.
they would cover the risk, the health component of the employees of UPS.
Okay, so with that company, the definition changing from international to captive, because they already exist in the territory, does their company have to change anything?
No. What they would be doing, they would be covering the risk, particularly the health insurance, for individuals outside of the territory. So they cannot do any business
Okay, so
here
they have it
in
here.
terms of covering risk associated with the employees.
Senator, I want to make sure we're clear on, there isn't any impact, this bill doesn't in any way impact any companies that are currently licensed.
That's good.
It's just a matter of changing the name that we traditionally use in the code, which says international insurer, to captive insurer or captive insurance company.
Time.
But it doesn't affect any current persons or entities that are licensed in the territory.
Okay, thank you for that. Thank you for the time, Mr. Chair.
Thank you, Senator DeGraff. Senator Carrion, you're recognized.
Good morning, Mr. Chair. Good morning to my colleagues. Good morning to the testifiers
Morning.
and the viewing and listening audience. Buenos dias. I don't really have much to say. I think this is a good proposed legislation because what you're doing is clearing up the language within our codes, which is necessary, and it's something that we're seeing that we have to do more and more. And in your case, to avoid any confusion within the industry, the language is being cleared up. So I just want to thank everyone who was involved, the sponsor of the bills, and the team for recognizing the need for this. And of course, it was brought up because of the accreditation agency and to avoid any confusion in the industry. Now, let me ask how many captive insurers we have in the territory?
Thank you for the question, Senator. We have 2 captive insurance companies right now.
How many?
2.
2?
Yes.
Just 2. Okay. Is there have you received requests for any more captive insurance companies?
Yes, Senator. We have 3 pending applications that we have sent out.
3 that are pending. Okay, very well. No further questions. I think this is good. There's a lot of things we have to clear up within our codes that we haven't revisited in a long time. So, good work. Thank you.
Thank you.
Thank you, Senator Carrion. You're inserting the definition captive insurer. So you're inserting it after K in 1401? And then renumbering accordingly?
Correct, because I think because we were using the term international insurer, we're deleting that term and then adding captive insurer in its place with the current description that was included in international insurer, as well as adding a definition for captive insurer.
Okay, and I'm just saying, so in alphabetical purposes, it'll be inserted in and then the next one will be deleted and then renumbered accordingly.
Correct.
Okay, should we, I'm looking at the way you wrote the amendment as to whether or not it's clear that that is what you want, or were you just seeking to put the definition captive insurance at the end of the particular 1401?
No, it would be renumbered and
be renumbered.
included in alphabetical order.
Okay,
Correct.
and then you did not Association International Insurance Company. You're not going to delete that? You're changing that to what? I don't see you didn't reference that. That's H.
Yeah, that would also be deleted, and
But you
we
amend,
worded to include captive insurer.
Okay, your amendment doesn't speak to Association International Insurance Company.
Yeah, that would be included also.
So we have to add that in.
Correct.
Okay, thank you so much. Point of inquiry, Senator Fred Gregory.
Thank you, Mr. Chair. Could you repeat that again? The chair asked a question. I'm trying to figure out
There
exactly
is a
the
term.
specific section.
Section 1401, Title 22, Section 1401H. There's a definition there for International Association of International Insurance Company. But we won't have an association anymore, so
Yeah, but the
is it-
international insurance
is
part
it-
would change. Yeah, the
So
captive insurance.
is it Association of Virgin Islands?
No, instead of saying Association of International Insurance Company, be Association of
Captive.
Captive Insurance
Insurance.
Company.
I
Okay.
see.
Correct.
I just wanted to make sure, when you scrub it, you made sure that every instance of international is gone, right?
Thank
Or
you.
I see you
was the
found more.
That was a difficult part, going to the entire code to make sure you pinpoint each area that it's the term is being used,
Okay,
because
and-
there was so much
so many
variation of the
instances.
term.
And since we are going to have some time before the Rules Committee, you can do a further scrubbing, and if you find any additional areas that need to be amended, if you can let us know, let the bill sponsor know. Senator James, you recognize.
Good morning to the people of the U.S. Virgin Islands. Thank you, Chairman VLA, for the time. What can you say when everybody already went before you? What can you ask? However, I just want to say congratulations to the Office of the Lieutenant Governor for the Division of Banking, Insurance, and Financial Regulation for being accredited. I remember when we supported that in the 33rd Legislature of the Virgin Islands, and we had a lengthy discussion. I think ever since then, you have been doing your due diligence, and that is why we're here today. But my question is, ever since that act was passed by this body, how many individuals or companies were able to slip through the cracks based on the discrepancy with the definition?
There wouldn't be no one who's going to slip through the cracks, because remember, the term, even though we were not using the term captive insurer, the definition and description and the intent of that chapter remain the same. So even though we were using the term international insurer, we know that means captive insurer. We know that means captive insurance company. We know that means captive insurance support business. It's just a matter, the uses of the term wasn't, and I think that came back. If you look, that's what I referenced, the different acts before it. Because as you will note, in different acts, there was that term that was being used traditionally in the act. And this is where I think the Senator was talking about cleaning up sometimes the code, because that term was just being used, international insurer, and we accepted it meaning captive insurer. The problem came about when other jurisdictions are using that term meaning something different from our intent. And this is where the need to make that revision, not only
1 minute.
internally changing the way we use that term, but making that revision in the code itself.
Because what I was leading to, and I'm happy that you clarified that, I was trying to find out if we were being proactive or reactive. So I guess we're being proactive. So thank you. That's a compliment. You should be happy about it. I see you
Thank
pushing
you.
up your face.
Thank you, Senator.
Anyway, it's a no-brainer legislation, and I just hope and pray that we continue to be accredited. It speaks to high standards when we realize that we're up there with the rest 50 states. So that's commendable of the division. And like I said, no legislation is perfect. And today is a great example of, even though at the time we thought it was something good at the time, we realized we have to come back and revisit it. So I'm happy that we're addressing it. And thank you, Mr. Chair, for the time. And today's a good day in the Virgin Islands when you wake up and hear that the refinery is going to be open and they're about to rehire. So Thank you, Mr. Chair, for the time.
Thank you, Senator. Thank you, Senator James. I won't comment on that. I'm waiting to see what officially is going on. At some point, I'm hoping that jurisdiction would be meeting with the members of the legislature so we can know exactly what is going on. But we have been working on accreditation legislation for what, 5 years now, right?
Yeah, it was a task because the components of accreditation is not only making sure you have all the necessary laws in place, but maintaining those laws as NAIC has the other model laws that they add to the purview that they indicate we need to adapt. We have to keep on moving. So it's a fluid, accreditation is a fluid situation, not only it relates to the laws, but how we as the financial service examiner have to examine the companies and supervise the companies. There's a lot more that the division, there's a lot more that the division, a lot more support the division will continue to need from the senators, because we're going to continually be coming to the legislature with bills as it's required to meet those accreditation standards as we go forward.
I totally understood. Senator Francis, you're recognized.
Thank you very much, Mr. Chair. Good morning to you, and good morning to my colleagues, and certainly good morning to the testifiers.
Good morning.
Good morning to the people of the Virgin Islands. It is, in fact, a good day, and you know, it's always good to give thanks and praise just for the fact of waking up in this territory. But I wanted to ask, and you know, the whole issue of insurance continues to be a very complex issue. Just hearing you read your testimony today, as well as to going over this measure, you could really see the complexities of insurance. How are we educating the public, so that they don't be disadvantaged in this whole insurance industry? Can you just touch on that for me, please?
Well, our staff continues to do a lot of outreach. As you know, like everyone else, as a result of COVID, we've reduced the amount of coverage we've had out there. But we will continue to do outreach. We're already planning for Ag Fair, which is one of the times that we have tables for all 3 days. Our staff is out there meeting customers, speaking to customers, indicating we have brochures, educational materials that will be available to customers, so that they continue to be informed as to different changes that's happening in the insurance industry.
So the term international and captive is really, I guess, interchangeable, and it's semantics, you'll say?
For us, it's interchangeable, but remember, if other jurisdictions are using it and they're using it in a different format, this is where the problem comes in.
Very well. And you mentioned that there was 2 captive insurers on island. Who are they?
We have Kenfield, and we also have Bay State USVI branch.
Okay. And what about the issue you mentioned about domicile? And that's certainly an issue that as we continue to contemplate the whole accreditation process, domicile continue to pop up. Are those 2 companies domiciled here in the Virgin Islands?
One has not started operations yet. It had been licensed in November 2017. The other one has been there, I think, since 2008. They are not, well, yes, the answer is yes, but the domicile is through a support business. So the support business is in Thomas, and they are the ones representing those companies.
Okay, and again, complexities of this whole discussion, right? And then you spoke about the fact that they cannot underwrite its own risk situated in the territory. Can you expand on that a little bit for me?
The current law as written provides that a captive insurer cannot underwrite its own risk in the territory, meaning in order to, it's a company that is domiciled here, but they're generally underwriting risk elsewhere. For instance, like Mr. Bertrand gave the example of UPenSco. Their coverage covers UPS the UPS facilities outside of the territory and not those within.
So
Time.
is there, Mr. Chair, if I just may conclude real quickly. So is there any benefit to them? Do they pay, banking and insurance for some registration, licensure, or whatever? Or what is the benefit of having them here? Besides, of course, they're covering the UPS employees. What is the benefit of having them here in terms of revenues that comes into the territory?
Well, there is registration requirement, and I'll have Mr. Burton speak to that.
Well, the main thing is they have the tax incentive benefits. If you look at the section in the code, if you're domiciled in St. Croix, you get 100% of a whole slew of benefits. In St. Thomas, it's 80%, and I think that was done to attract more business in St. Croix. But the main advantage, if you look at the benefit section, is a whole slew of benefits that they get being a captive. Like I said, it's 80% in St. Thomas and 100% in St. Croix.
Very well. Thank you. Thank you very much for your responses. Again, we have to continue to educate the public on this particular issue. Thank you, Mr. Chair, for the time.
Thank you so much, Senator Francis. Senator Sarro, you recognize?
Thank you and good morning. Attorney, can you hear me? I have a feedback over here.
We're hearing you.
Can I be heard?
Yes.
Okay. Attorney Matthews basically answered some of the concerns that I had, and I'll be a bit redundant, but I'm looking at the code now, and I'm doing a comparison with the legislation. And so when we strike international insurance, does the amendment define an international insurance company? Because I'm looking at the code now, and if we strike that, do we intend to define an international insurance company, Ms. Matthew? Attorney
Remember,
Matthew, sorry.
Keep in mind, the purpose of the bill and the amendment is that we're no longer going to be using the term international insurer. We're going to be using the term captive insurer. And there is a definition in the bill as has been submitted for captive insurer. The descriptions that were used for international insurer, that has been carried over into the not only the definition for captive insurer, but those descriptions are listed there.
Okay. So excuse my ignorance here. So an international insurance company that verbiage would not exist in the code after today?
Correct. International insurer, international insurance company, international support business, all the reference to international would say captive in its place. So the term international in regards to Title 22 and Title 13, Chapter 14 would refer to captive in the place of insurer or insurance company.
Okay, because the legislation does not, I guess an amendment would be forthcoming, but the legislation did not, the title that, the section we're citing and the changes that we're making is not applicable throughout, and that was a question I had.
Correct.
1 minute.
I understand what you're saying now. Okay. Excuse my ignorance on the topic, but thank you for answering my questions.
Thank you,
Mr. Chair,
Senator.
for the time.
Thank you, Senator Sarro. And there is an amendment that will be, it's not completed yet, but we can send you a copy of the amendment that would make some of those corrections that you just cited. The only question, though, we define in captive insurer, right? It's defined in Section 1. I'm looking to see if we deleting, or you deleted in the amendment, I think you deleted T, right? Did you?
Yes.
Okay, so that's...
Because remember, we're going to renumber where captive in.
So that is where the confusion is, because the amendment deletes T. So the amendment deletes the definition of international insurance company, because you have the definition of captive insurers.
Correct.
Okay. For consistency, they want to leave captive insurer, insurance company, or captive insurer?
This is why in my recommendation I said captive insurer means also known as captive insurance company. So that, because there is so much areas where it's referenced that it's hard to, unless you're gonna change every place that it says international insurance, captive insurance company to captive insurer, it's referenced throughout the code in different fashion because of the because I think what happens is every time an act is created, some says insurer, some says insurance company, although it means the same, it's referenced differently. And as a result, throughout the code, it's referenced differently.
Okay.
So we just want to make sure wherever we say captive insurer means also known as captive insurance company.
Okay. Senator Joseph, you recognize.
A pleasant good day, Mr. Chairman, colleagues, testifiers, my people of the Virgin Islands. Attorney Matthew, kindly accept my thanks to you and your team for your drive to assure that the Virgin Islands have now achieved National Association of Insurance Commissioners accreditation, and I understand clearly what the purpose of this legislation is to assure that we maintain that level of high standards to promote effective insurance company financial solvency, as you stated in your presentation. Now, let me ask you, if we do not pass this legislation, we will be at risk for losing our accreditation with this national insurance standard company, correct?
Yes, because keep in mind, we're all only here for a time. We can argue every time that we go off accreditation, which is every 5 years, what international insurer means. But at any point in time, and myself is not here, Attorney Richards aren't here, there is someone who's going to have to come before that accreditation team and make the same argument. So we want to make sure that every 5 years we're not having the same discussion regarding the term international insurer and having to make that argument to the NAIC accreditation team.
1 minute.
Okay, great. And so, thank you. Now, I wanted to ask you, have any of your local stakeholders, those two companies who are captive insurance insurers in the Virgin Islands, had any input on this legislation?
No, but I did remember I'm sure before we brought this legislation, most of you would say you weren't even familiar with that term, because you would say you would be familiar with captive insurer, but you haven't been familiar with international insurer. So
But if I may, Attorney Matthew, because does this have any far-reaching effect on those two companies who are currently captive insurance companies and those who are in the pipeline and being considered for to be a captive insurance company or insurer? Does this legislation have any effect on their pending process and those who are currently have those certifications?
No, it does not. The intent of the legislature was that international insurer and international insurance company are acting as in the capacity of captive, and that is a captive insurance program. So there's no impact on any of the captive currently licensed or future persons or entities seeking to be licensed under the captive program.
Okay, thank you kindly. You have answered my question.
Thank you, Senator Joseph. And all it's doing is cleaning up the language to comply with NAIC standards. So, in fact, it is good. It is not going to affect us in any way negative. It's going to be a positive effect because it is clear that what the international insurance companies were doing were actually captive insurance. So we're just clearing it up and allowing them to be able to function in the Virgin Islands. Senator Fred Gregory, you're recognized.
Thank you, Mr. Chair. So we are basically doing some cleanup language today. However, I think what's important for all of us to understand is what does NAIC certification mean to the Virgin Islands, to the Division of Banking and Insurance? What does it mean? Why is it necessary for us to, one, have this discussion, to make these amendments to the law? What about it?
NAIC, National Association of Insurance Companies, Commissioners, is an organization that is created that all commissioners of all jurisdictions and territories are included. Within that, there is an accreditation standard that was created for all states to follow. The division, until recently, was not accredited, meaning when we do an examination of an insurance company, no other state would have relied on our examinations. Now, because we're accredited, we can do an examination of all domestic companies that are doing business in other jurisdictions, and those jurisdictions rely on our examination, which would encourage more companies to come here and become domiciled here, because they're not going to be subjected to two different examinations, one in our jurisdiction and one in another jurisdiction wherever they are a non-domiciliary state.
Thank you for your response. I think that was very important information to be placed on the record. But let me ask you very quickly, because I don't really have a lot of questions myself, but let me ask you.
1 minute.
So a corporation that wishes to offer captive insurance, this captive insurance program, are they required to have a certain number of employees? Is there any requirements around that?
As the statute is written, they do not require to have a certain number of employees per se, but they are required to have a support business in the territory in order to operate. So a company in Vermont, for example, cannot just say, we are doing business in the Virgin Islands. They either have to be domiciled here, or they have to have a support business who will act on their behalf.
Okay, so they either have to be domiciled here, or what did you say?
Domiciled here physically,
yes,
or act through a support business who would be a service provider in the Virgin Islands.
Okay, that's important information. I think you've already explained to us the significance of striking international and replacing with Virgin Islands captive insurance. So this act will be now called, if this is approved, will be now called the Virgin Islands Captive Insurance Act.
Time.
Correct.
And what was it called before? What is it currently called?
It's currently called Virgin Islands International Insurers Act.
Okay, thank you. I have no further questions. Thank you, Mr. Chair, for the time.
Thank you, Senator Gregory. Mr. Bertrand, when you spoke about benefits, that the companies are possibly able to receive 80% St. Thomas, 100% St. Croix, that is under the EDC?
No, it's under, if you look at section...
So it's separate?
Yeah, section 1415 of the Act tells you exactly what the tax rates and the applicable benefits to the international insurance company, well, now, after the legislature has done what they intend to do, then to be captive insurance. But under 1415, That's where the benefits come. If you're really careful, you'll see that if you're established or licensed or domiciled in St. Thomas, then you will get 80%, and it has a whole slew of it has property taxes, it has also income taxes and some of the other taxes under Section 1415.
And also there is Title 13, Chapter 14, which speaks to exempt companies, and one captive insurer can be an exempt company under Title 13, Chapter 14 of the Virgin Islands Code.
Okay, I'm seeing it on international. It'll be a captive insurance company is exempt from any other taxes imposed by the Virgin Islands, including without limitation real property tax used in a business of the captive insurance company, gross receipt taxes, excise taxes, and premium tax.
Yes. So,
Going back to the previous senator question, should we have some provisions in there, whether it's a support company or a domicile company in reference to limited number of individuals that are hired? In order to receive the benefits, you need X amount of employees, or if it's a support company, the support company should expand by X amount of employees in order to receive the benefits? Just your viewpoint.
You're asking for a yes or no?
Well, you could explain if you want to expound. I'm saying we're given some benefits, right? I mean, the idea is that we want to really get insurance companies to come. But should there be any other tie-in to receiving those benefits that could potentially impact the Virgin Islands?
We can look at that, Senator. I know relative to the captive law, you tend to look at the other jurisdiction also to see what is being offered in other jurisdictions to be competitive. So we would have to look at other jurisdictions to see how their captive law is written, if it does include those type of additional requirements also, and we can consider it.
And Senator,
Well, we can look at it and see how other jurisdictions deal with that.
Yeah,
Okay, thank you so much, Mr. Bertrand.
Yeah, if I may say, I have attended a couple of conferences, and also we have an informal captive regulators association, probably close to between 45 and 37 of the regulators have a mailing list where we go back and forth. And I might be wrong, but I don't know any of the states that have a employee or number of employees mandate. And if that may be the case, like Assistant Director Matthew said, that's a good thing to look at. But if none of the states are doing it, which I don't think they are, because we speak on a regular basis, then that would hinder us in terms of having captives coming. But I'm pretty sure that none of the other domiciles are doing that.
Okay, thank you so much. Just inquiring, any opportunity we have to expand employment, I think that we need to look at. Colleagues, anybody else has a question? Any other burning concerns? So that is no. We have received a copy of what was filed or what was recommended, and it's in the testimony in reference to the amendments that were recommended by Attorney Matthew Colleague. So those amendments have been submitted to legal counsel, and the amendments will be offered at the next meeting, which will be the next juncture, which will be when it goes to the Rules and Judiciary Committee. So at this time, I'm asking for a motion. Motion, Senator Gregory.
Thank you, Mr. Chair. I move that Bill number 34-0191, an act amending Title 22, Virgin Islands Code, Chapter 55, relating to captive insurance companies to clarify the purpose of the chapter and to prohibit the organization within the Virgin Islands of a special category of multi-state insurance that may not be required to comply with the accreditation standards established by the National Association of Insurance Commissioners and adopted by the territory as a NAIC accredited jurisdiction be favorably approved by this committee and forwarded to the Rules Committee for further consideration. I so move.
Motion made by Senator Fred Gregory, seconded by Senator James. Senator Blyden, roll call.
Senator Marvin A. Blyden. Senator Blyden, yay. Senator Samuel Carrion. Senator Carrion, absent. Senator Dwayne M. DeGraff. Senator DeGraff, yay. Senator Donna A. Fred Gregory. Senator Fred Gregory, yay. Senator Javon E. James Sr. Senator James Sr., yay. Senator Janelle K. Sarow.
Yes.
Senator Sarow, yay. Senator Kurt A. Vialet.
Yes.
Senator Vialet, yay. Mr. Chair, you have 6 yeas, 1 absent.
Thank you, Madam Clerk. Bill number 34. Who's absent? Bill number 34, that's 0191, an act amending Title 22, Virgin Islands Code, Chapter 55, related to captive insurance company, to clarify the purpose of this chapter, to prohibit the organization within the Virgin Islands of a special category of multi-state insurers that may not be required to comply with accreditation standards established by the National Association of Insurance Commissioners and adopted by the territory as a NAIC accredited jurisdiction, has received a favorable vote in this committee and will be sent to the Committee of Rules and Judiciary for further consideration. The Committee of Finance will take a 2-minute recess.
We are back on the record. Madam Clerk, can you read the next item on today's agenda, please?
Bill number 34-0204, an act amending the Virgin Islands Code, Title 22, Chapter 58, relating to self-insurance, and Title 29, Chapter 10, Section 543, relating to the powers of the Port Authority to authorize the Virgin Islands Port Authority to establish a self-insurance program to cover and manage certain risks. Proposed by Senator Kurt A. Viale. Invited testifiers, Carlton Dow, Executive Director, Virgin Islands Port Authority. Glendina P. Matthew, Esquire, Acting Director, Office of the Lieutenant Governor.
Thank you, Madam Clerk. Before I go to the sponsor of the bill, Senator Viale, to introduce the bill, I see we have Attorney Fraser also on Teams. Attorney Fraser, can we have a mic check quickly, please?
It's good morning, afternoon.
Good afternoon, Attorney Fraser. And we do have, of course, Attorney Matthews still in the well. Is Senator Dow available?
No, Mr. Dow is out today. He had a medical emergency, so he won't be available today.
Okay, very well. Senator Viale?
Okay,
I apologize. Sorry for that. Thank you so much. Senator Viale, you recognize for the introduction of your bill.
Thank you so much, Mr. Chair. Bill number 34-0204 speaks to the authority or provide an authorization for the Port Authority to establish a self-insurance program that would cover basic items like vehicles and the buoys and the bollards. This in no way gives them the authority to be able to insure real property. It's just giving them that authority to self-insure those smaller items in which they're paying a substantial amount of money for right now. And looking at the analysis, if this bill is successful, it would save the Port Authority some $500,000 a year, because just about every single year we're paying out less than we have paid for the actual cost of the insurance, and substantially less. Before we started the meeting this morning, we had the opportunity to speak to the Office of the Lieutenant Governor, Attorney Matthews and Attorney Richards. And we had a discussion as to whether or not the self-insurance portion needed to be embedded under the Office of the Lieutenant Governor. In the discussion with the Office of the Lieutenant Governor, the two attorneys, along with Attorney Fraser and along with Attorney Tops, we realized that we do not need to place it under the Lieutenant Governor, but we just need to give the Port Authority authorization under Title 29, Chapter 10, Section 543. So we just need to give them authorization under that particular section, and hence we are going to strike all of the language that speaks to authority being given by the Lieutenant Governor Office, or certification or recertification. So the components, colleagues, of the bill that would remain is going to be the definitions, which is 1495, the self-insurance authorization A, B, and C will be striked. 1497, insurable assets, that will remain. 1498, management will remain. 1499 speaks to the Office of the Lieutenant Governor. That entire section will be struck. And 1499A, renewal, will also be striked. 1499B will change the maintenance of self-insurance, and then the word commissioner would be deleted and replaced by program administrator. There's a lot to contest, but we had spoke with all the senators who were here. I think everybody fully understands, so we're going to make those recommended changes. so that we can have the Port Authority immediately begin the self-insurance program that will save the authority some good money in these difficult times of being holding on to cash. And the bill speak to maintaining a capitalization of not less than $200,000. Okay, and they would be responsible for all liability for those particular areas. So colleagues, the amendment is going to be submitted. I'm glad that we had a number of senators here today. It's going to be submitted so that we can move forward. But I'm asking for your support, and with the meeting that we had this morning, that we're able to move it to the next committee and have those recommendations or those amendments be placed on the table at the next level. Thank you, Mr. Chair.
Thank you so much, Senator VLA, for that explanation of the bill. I see Attorney McLean on Teams. Good afternoon, Attorney McLean.
Good afternoon, Senators.
Good afternoon also, Attorney Richards from the Lieutenant Governor's Office. Good afternoon. So I guess we're going to begin with Attorney. Point of information, Senator VLA.
Thank you so much, Mr. Chair. Exactly what I said was the recommendation that the attorney really has in her testimony. So I'm requesting that only Attorney Fraser provide testimony because it will no longer fall under the Office of Lieutenant Governor. So if we can just go straight to Attorney Fraser and then move on it.
Very well. Thank you for that. Point of inquiry, Senator DeGraff.
Thank you, Mr. Chair. In regards to the way we want to move forward, because the bill exists as standing, even though the government put in their point of view and we agreed to move forward with it, to do just Attorney Fraser's own would be for the same bill, or should we just then go ahead to make a motion and just move the bill forward since we agreed to it, whether he have to testify and we have the government here and they don't get to state their side. If they agree to it, then let's move it forward. Thank you for the time, Mr. Chair.
Senator Vialli, recognized for your point of...
Attorney Fraser's testimony really explains what the Port Authority is trying to achieve. So it would be important just to get that on the record in terms of, and he's given a whole background financially and what they'll be able to achieve if this bill is passed. So it would be good just to have that on the public record as to what they're hoping to achieve.
Point of...
Yes, thank you. But again, thank you. I was just saying that the bill exists, 34-0204 exists. So to just have, it involves the government. And the government, like I said, put in their 2 cents. Mr. Attorney Fraser put in his own. If we agree to move it forward to rules and have it fixed by rules, then let's just go straight to that. Because I'm saying if we can put on what Attorney Fraser is going to say, he's going to say it in regards to what we are looking to do. But what before us is Bill 34-024.
Okay.
That's what I was talking about.
Okay, Senator Graff, I get what you're saying, so I believe, Mr. Chairman, Senator Vialli, I believe we should just have both testimony on the record if that's the case. That way the public can hear it and let's move forward. Okay, so Attorney Fraser, you recognize for your testimony.
Thank you. Thank you, Mr. Chairman. Good afternoon, Honorable Senator Marvin Blyden, the presiding chairperson of the Committee on Finance, and the honorable senators of the Committee on Finance of the 33rd Legislature, all legislative staff, and to the viewing and listening audience. I am Vincent F. Fraser, Senior Staff Attorney for the Virgin Islands Port Authority. I am testifying on behalf of Mr. Carlton Dow, the Executive Director for the Virgin Islands Port Authority. Mr. Dow sends his apologies for his absence, which is due to a medical emergency that he is experiencing today. I'm here today to present testimony regarding Bill number 34-0204, an act amending Title 22 of the Virgin Islands Code, Chapter 58, primarily relating to self-insurance for the Virgin Islands Port Authority. This act authorizes the Port Authority to establish a self-insurance program to cover and manage certain risks. It's intended, the self-insurance program will be established, was initially designed to be done under the critical requirements of Title 22, Chapter 58, Self-Insurance Fund. However, with the discussions that we had this morning, I will simply go to the specific means by which it benefits the Port Authority. The Virgin Islands, many jurisdictions have certain types of, I'm sorry, just a minute. The Virgin Islands government, under Title 22, Chapter 58, we have a commercial self-insurance fund. But this program under Chapter 58 does not authorize a government entity to operate a self-insurance program. However, our research has shown that other jurisdictions allow certain types of government entities to establish self-insurance programs as a cost-saving measure and to manage their own risk. Government entities which are permitted to self-insure include such entities as school districts, municipal water management entities, colleges and universities, and municipalities. Several states and foreign jurisdictions have authorized the creation of several self-insurance programs on various levels. A list of these jurisdictions has been provided with the statement. In order for the Virgin Islands Port Authority to set up such a program, the legislature must provide the Virgin Islands Port Authority with the statutory authority to do so. Section 2 of Bill 34-0204 expressly provides the authority for the Virgin Islands Port Authority to establish the self-insurance program. VIPR is seeking this authority to expand its risk management program. The risk management program is anchored by the $75,000 statutory liability cap that was enacted in Act number 7574 back in 2013. By having a self-insurance program, Port Authority will attain considerable savings in insurance premiums. At the same time, the public will be protected by having an identifiable fund from which claims can be directly paid. The public is protected also because the authority comes with a mandate that Port Authority must maintain a minimum of $200,000 in a special self-insurance fund. VIPR's interest in this change in the law allows for a self-managing risk related to third-party coverage, i.e. premises liability, vehicle accidents, vessel accidents, and small asset coverage, marine markers, and marine equipment. VIPR will continue to use commercial insurers to insure and transfer risk of loss with regard to damage or loss of buildings, airports, seaport terminals, and other high-risk assets. The self-insurance program will assist Port Authority to reduce its operating costs, particularly in a time when the operating revenues have been significantly impacted by COVID-19 pandemic. The self-insurance program will allow us to keep some control of funds that would otherwise be paid out as high premiums and allow Port Authority to put money back into our operations to take care of maintenance, repairs, and other risk management initiatives that would further mitigate risk. Since 2020, we have seen our insurance premiums for third-party related risk increase by 31%. The increases we have seen were impacted by the insurance market conditions, the COVID-19 pandemic, and by natural inflation. For fiscal 2020, Virgin Islands Port Authority insurance premiums for coverages other than first-party property insurance, that is for buildings and disaster-type insurance, the cost was $1,214,437. In 2021 fiscal year, Port Authority paid $774,257.65 in premiums for the same coverage. By introducing a self-insurance program, Viper could see savings of more than 30% of its overall premiums. In 2018-2019 policy year, Port Authority had losses that were less than 50% of the premium costs. These losses were less than $300,000. The final loss amount for the year 2020 to 2021 is currently still being determined. However, we believe that the ratio will be almost the same. Over the last 5 years, Port Authority has paid approximately $1,280,949 for premium costs for liability and property damage coverage for our automobile fleet. At the same time, for the same period, 5 years, Viper has losses of approximately $500,000. Thus, Port Authority paid premiums over losses of over $600,000. On the marine side, we have the same ratio of premium over losses. Therefore, we are certain that we can save significant dollars by managing our risk through a self-insurance program. If the Port Authority is permitted to establish this self-insurance program as designed in Bill number 34-0204, Viper can potentially recognize savings of more than $500,000 a year in premiums. Further, the allocated claim reserves that build up in this insurance fund could be used to capitalize future risk mitigation expenses and the activities within the Port Authority that currently go unfunded and sometimes without funding at all. Under this proposal, we have a management system which is designed in the law that would allow the Port Authority to designate under the CFO of the Virgin Islands Port Authority, it would be the designation of a self-insurance plan administrator who would be responsible for the day-to-day operation of the fund. Mr. Chairman, we believe that the Port Authority would be able to, with the assistance of our professional risk management consultants, we will be able to manage a self-insurance program that will be viable and provides protection for the public and protection for the assets of the Port Authority. I thank you for this opportunity to present this testimony in support of this legislation that will help improve the financial standing of the Virgin Islands Port Authority. As a self-sustaining autonomous government agency, the Port Authority must find methods to operate as efficiently as possible and to maximize the use of the revenues generated. We appreciate this legislature's favorable consideration of Bill number 34-0204, which will allow us to accomplish this goal. This concludes my testimony, and I am available to answer any questions that you may have. Thank you, Mr. Chairman.
Thank you, Attorney Fraser. Thank you. Attorney Matthew? Attorney Richards?
Richards will speak on behalf of the Division of Banking and Insurance.
Okay, thank you.
Good day to the Honorable Kurt VLA, Chairman and honorable members of the 34th Legislature of the Virgin Islands Committee on Finance, other senators present, as well as the viewing and listening audience. I am Attorney Suzette Richards, legal counsel, appearing on behalf of Attorney Glendina Matthews, Interim Director of the Division of Banking, Insurance, and Financial Regulation within the Office of the Lieutenant Governor and Commissioner of Insurance, the Honorable Tregenza A. Roach, Esquire. I most respectfully appear before you today to provide testimony on Bill number 34-0204. Oh, sorry. An act amending Virgin Islands Code Title 22, Chapter 58, relating to self-insurance, and Title 29, Chapter 10, Section 543, relating to the powers of the Port Authority to authorize the Virgin Islands Port Authority to establish a self-insurance program to cover and manage certain risks. I'm accompanied by Attorney Glendina Matthew, Interim Director of the Division, and Attorney Dolis McLean, Legal Counsel for the Lieutenant Governor and General Counsel for the entire Lieutenant Governor's Office. We most respectfully inform this distinguished committee that the division does not support Bill number 34-0204 as currently written. While the division does not object to the Port Authority creating a self-insurance program under provisions set out by the legislature, this should be done in another section of the Virgin Islands Code. The division would object to the creation of such a program under Title 22 of the Virgin Islands Code, which falls under the jurisdiction of the Commissioner of Insurance. Accordingly, the division does not support the bill for the following reasons. First, self-insurance funds are generally not regulated. The division has a dual legislative mandate. One, to regulate the banking, insurance, and financial services industries in the territory, and equally so, second, to protect consumer interest. However, Bill number 34-0204 is seeking to establish a self-insurance program for the Virgin Islands Port Authority under Title 22 of the Virgin Islands Code. Most commonly, self-insurance is akin to a trust account in which funds are set aside to pay for potential future losses. In the insurance industry, self-insurance funds are generally not regulated. While Chapter 58 of Title 22 of the Virgin Islands Code does include statutory provisions that would relate to a commercial self-insurance fund, it is important to note that Section 1480B of that chapter defines a commercial self-insurance fund to mean a group of members operating individually and collectively through an association. And Section 1480B further specifies the type of associations that would qualify under that section. Accordingly, the provisions in Chapter 58 would be limited to associations that qualify under Section 1480B and would not apply to an individual business or even a government entity like the Virgin Islands Port Authority. It should be noted that Section 1496B of the proposed bill provides that the Commissioner of Insurance may waive any requirement that currently appears in Chapter 58 that may not be applicable to the Port Authority as a government instrumentality. However, as the provisions that currently appear in Chapter 58 would not be applicable to a government instrumentality like the Port Authority, it is unclear what provisions of Chapter 58, Section 1496B, is intending to waive. Second, the Commissioner of Insurance does not generally license, regulate, or supervise government entities. The Commissioner of Insurance regulates private individuals and private entities that are involved in the business of insurance. The Commissioner of Insurance does not generally license, regulate, or supervise any government entity, and it does not currently license, regulate, or supervise any activities of the Virgin Islands Port Authority. Rather, government entities like the Virgin Islands Port Authority would be governed by the statutory provisions that apply to the government entity, and the government entity could generally issue regulations that would govern their activities to the extent authorized by law. It is important to know that Section 1498 of the proposed bill states that the governing board of the Port Authority would have general oversight over the self-insurance program, and it further gives the governing board the authority to adopt regulations as may be necessary or desirable in administering the self-insurance program. Third, the Commissioner of Insurance does not generally co-regulate the business of insurance with regulated entities. The proposed bill includes provisions that would appear to allow the Virgin Islands Port Authority self-insurance program to be subject to regulations that are issued by both the Port Authority and the Commissioner of Insurance, and further appears to require the Commissioner of Insurance to consider the Port Authority's regulations in determining whether it should be issued a certificate of authority. As was just noted, Section 1498 of the proposed bill states that the governing board of the Port Authority would have general oversight over the self-insurance program and the authority to adopt regulations as may be necessary or desirable in administering the self-insurance program. Section 1499(6) of the proposed bill requires the Port Authority to file an application for a certificate of authority that would include the regulations and the policies of the agency related to the self-insurance program. Section 1496(b) of the proposed bill indicates that the Port Authority self-insurance program would be subject to the regulations of the Commissioner of Insurance, although Section 1496(b) also indicates that this would be to the extent considered reasonably necessary to protect the Port Authority and the public interest. Section 1499(a) of the proposed bill requires the Commissioner of Insurance to examine the Port Authority's application for a certificate of authority under Section 1499 to determine the agency's ability to comply with the subchapter in the proposed bill and applicable regulations. However, not only does the Commissioner of Insurance not regulate government entities, the Commissioner also does not generally co-regulate the business of insurance with regulated entities, such that the Commissioner would consider the regulations of the Port Authority in determining whether the Port Authority should be issued a certificate of authority. Further, the division is a consumer protection agency, and insurance regulations would be construed to protect consumers and the public interest, not to protect the Port Authority. Any proposed bill that includes a matter that is placed under the jurisdiction of the Commissioner of Insurance should clearly set out the Commissioner's overarching authority to regulate the matter and protect consumer interests in a manner that is consistent with the mandate of the division. Fourth, the proposed bill appears to lack any enforcement mechanism. The proposed bill does not appear to include any enforcement mechanism. While Section 1499(a) of the proposed bill appears to speak to issuing, renewing, and refusing a certificate of authority, there does not appear to be any provisions that would address the suspension or revocation of a certificate of authority. The proposed bill also does not appear to note any other enforcement mechanism, such as a cease and desist order, that would apply to the Port Authority. There are a few other things the division would like to note about certain provisions in the proposed bill. First, Section 1495(2) of the proposed bill defines Commissioner to be the Virgin Islands Commissioner of Banking and Insurance. However, Commissioner is generally defined to be the Commissioner of Insurance of the Virgin Islands in Title 22 of the Virgin Islands Code, and further, the division is now the Division of Banking, Insurance, and Financial Regulation. Second, Section 1497 of the proposed bill, which sets out the insurable assets that would fall within the scope of the Virgin Islands Port Authority's self-insurance program, is potentially overbroad. Section 1497(a) of the proposed bill states that the Port Authority may not seek to self-insure the first-party property aspects of its real property assets and the improvement thereon, or the employee medical and health program. Section 1497B of the proposed bill provides that the Port Authority self-insurance program must cover the following categories. 1, its general liability risk in whole or in part. 2, its motor vehicle liability risk in whole or in part. 3, its third-party injuries. And 4, any other risk not excluded by this section. The term medical and health program, which appears in section 1497A, is not defined in the proposed bill. However, life insurance is not generally considered to be medical or health insurance. Accordingly, as life insurance has not been specifically excluded in section 1497A, it could be included in the Port Authority self-insurance program under section 1497B4, and it is not clear that including life insurance in the Port Authority self-insurance program would be consistent with the legislative intent of the proposed bill. Finally, the portions of section 1497C in the proposed bill that relates to the approval of premiums is unclear. Section 1499C provides that the fund that is established to cover the liabilities of the Port Authority self-insurance program must maintain a capitalized amount of no less than $200,000. However, as the proposed bill sets the monetary amount that the fund must maintain and is further requiring the Port Authority to obtain this amount from its general funds, it is unclear what premiums the Commissioner of Insurance is being asked to approve. Chairman VLA, members of the 34th Legislature of the Virgin Islands Committee on Finance, other senators present today, and the listening and viewing audience, the division's hardworking staff members are unequivocally dedicated to regulating the banking, insurance, and financial services sectors in the territory and protecting the interests of Virgin Islands residents. This concludes the division's testimony on Bill number 34-0204. We thank you for the opportunity granted to the division to appear before you today. We're prepared to respond to your related questions.
Thank you for your testimony. Attorney Richards and Attorney Matthew, you care to put anything on the record in reference to the discussion we had, in reference to all of your suggestions and the conversation with Attorney Tops and also Attorney Vincent Fraser that addresses your concern?
Good morning again, Glendina Matthew, Acting Director. Based on our discussion this morning, the division has no objection with the bill being amended to exclude the supervision or licensure by the Office of Lieutenant Governor, Division of Banking and Insurance, and the bill being amended to just include an enabling clause to the section that governs the VI Port Authority.
Okay, thank you so much. Colleagues, let's go to 3-minute round. And once again, all the concerns that were listed by the Office of Lieutenant Governor has been noted, and we will make the requisite changes where the self-insurance program for the Port Authority will not fall under the Office of the Lieutenant Governor, but the enabling clause would give the Port Authority the authorization to enter into a self-insurance program, and then certain areas will define to include insurable assets, management, and maintenance of self-insurance. So we went through the suggested language. There'll be no reference to the Lieutenant Governor office, no reference to the commissioner. Where you see commissioner in maintenance of self-insurance, that's going to change to the program administrator who is the CFO for the Port Authority. So the completed bill will just deal with the Port Authority in Title 29, Section 10.543 for the authorization to establish a self-insurance program, and in the other areas, we're going to find a section where we put it in. So Point of inquiry, Senator Fred Gregory.
Thank you, Mr. Chair. So I'm trying to understand. So Port Authority will engage in a self-insurance program, or are we giving the authorization for the Virgin Islands Port Authority to be self-insured under certain categories? I'm a little unclear about that word program. Somewhat concerns me because it appears as if the Port Authority has to put a system in place, whereas in the GVI, we have a self-insurance. The government has self-insurance, but there isn't a self-insurance program per se. It's a given that if there is an event where we are self-insured, like a vehicle, if you will, then the government will pick up the cost via the tort claims or whatever that is. So I am still a little put back about the terminology program. So I just need some clarification around your thoughts on that as to whether or not a program really needs to be established, or is it just authorization for self-insurance for those various categories outlined. Thank you.
It is authorization that is granted by the legislature to allow VI Port Authority to perform or have a self-insurance fund. Program is just a word to use in terms of how you manage the fund, but it is a self-insurance fund. That you needed.
Do you have a follow-up question, Senator?
And I think that the way, and I think the Port Authority may be able to speak to this, but the way this was drafted and based on some of the things Senator Viale will allow to remain, it would give them the opportunity, like the management section would specifically lay out how it would be managed and also give them the authority to issue the rules and regulations. You have the section on insurable assets that would specify the assets that could be included within the program, because this particular bill does lay out things that are excluded. For example, the first-party property risks. They're not meant to be included in this program, or employee medical and health insurance, but other things would be. So then there's the maintenance of the self-insurance, at least according to the way the bill is drafted.
The chairs are, if you would allow,
Go
the chair
ahead, Senator.
noted that there will be changes to how the bill is drafted, but then I'm still concerned that if there's, I just don't see the need for all of that language around what authorization they have, because if we move forward with that amount of language, then the issue here is they can't have a minimum of $200,000. That presents an issue. When you look at, and I could get into it in my questions, I'll do that. So I'll just wait until it's my turn, but I do have some concerns around that amount, and then the terminology program, or even the terminology fund, if you're only capping it to maintain a minimum of, I think there needs to be some additional requirements. They claim that they're now paying some $1 million, so there must be some commitment on an annual basis to continue to stack that program. Thank you, Mr. Chair. I'll wait until
Thank
my turn.
you, Senator Fred Gregory. But Attorney Fraser, you want to comment?
Well, yeah, yes, I mean, Senator. Good afternoon, Senator Gregory, Fred Gregory. The idea of the program is to ensure that the Port Authority's self-insurance is done in a systematic way that not only for the benefit of saving money for the Port Authority, but to make sure that it maintains the financial integrity that's necessary to protect the public. And so a lot of in the way the bill was drafted, it was given the opportunity to have an independent review by an entity like the Commissioner of Insurance to make sure that all of the necessary requirements for a viable insurance program would be in place. Now, although if the law is changed and it provides for the to exclude the Commissioner of Insurance, the governing board of the Port Authority still has a fiduciary duty to ensure that the program is maintained in a viable way. And the retention of a program manager or plan administrator would help to make sure that the risks are measured against the premiums. The premiums are determined in an actuarial sound way, and therefore, so that although the minimum is $200,000, the Port Authority, once it's determined to be established with the premiums in an actuarial sound manner, that premiums would then have to be added in as necessary based on past claim experience. So the word program basically is to make sure that it's done in a systematic way, not just a sinking fund with money controlled by the Port Authority.
Okay, I know you have more questions. We'll come back because we need to make sure that we get it clear. But in section 543, it defines the powers of the authority. And that is where, under those powers of the authority, we're now saying that the authority also has the right to establish a self-insurance program. So we put in it in the statute that defines the power of the authority, powers of the Port Authority, and expanding that to mean that, or to include the ability to self-insure. The other language that we're keeping, which includes the definitions with the exception of commissioner and insurable assets, define exactly what falls under the self-insurance program and what doesn't. So we don't want to leave it up to the Port Authority to decide what would fall under self-insurance. So here it clearly says that they cannot self-insure first-party property, real property assets, employee medical and health program, and we're adding in life. And then it goes on to say the self-insurance can insure general liability risk in whole or in part, motor vehicle liability, third-party injuries, and any other risk that is not excluded by this section. And the language really includes bollards and buoys, etc. The bill then goes on page 4 to establish the way that the program, or who will be in charge of the program, which is the chief financial officer, who will be known as a program manager. And then it talks about risk management. So the other components of the bill is just to actually define exactly how the self-insurance program is going to operate. And the last section will be the maintenance of the self-insurance, where we speak into how the program will function year in and year out. Senator Blyden, you recognize.
Thank you so much, Mr. Chair, and I believe the amendment will help to clarify and clear up a lot of the gray areas. Because the discussion we had this morning assisted me in realizing exactly what the intent is, and I do agree with the Lieutenant Governor's office in respect to that. Just briefly, Attorney Richards, in respect to the Port Authority, because I know self-insurance is not regulated, but at the same time, based on the rules and regulations and the policies, it must be up to par in order for you guys to approve them in terms of having the go-ahead to do such a program, correct?
No, our office wouldn't have any approval. Self-insurance is generally not regulated, and our office, we don't regulate government entities. So
the certificate of authority I'm talking about.
I'm
certificate
sorry?
of authority.
Yes, the certificate of authority would be for companies.
Okay.
Yeah.
Okay.
Generally, a certificate of authority under the code would be used to give insurance companies, either domestic, foreign, or alien insurance companies, the authority to engage in the business of insurance in the territory, depending on the type of business they want to write. whether it's property casualty, life, health, title, whatever the case may be. That's generally what a certificate of authority does.
Okay, thank you for that.
No problem.
And Attorney Freed, I just want to give kudos to the port authorities for being creative in terms of finding ways to assist the agency in terms of reducing costs when it comes to operation and at the same time assisting in risk mitigation, etc. So thank you for what you guys continue to do, and I want to thank you guys for your
1 minute.
testimony. Thank you so much, Mr. Chair, for the time.
Thank you, Senator Blyden. Senator DeGraff.
Yes, thank you, Mr. Chair. Good afternoon, everyone. Good afternoon, colleagues. Good afternoon, testifiers.
Good afternoon.
So as the bill, as it is right now, we don't agree on it. We had our separate meeting, and the amendments that we're looking to do to give Port Authority by the legislature the authority to form their own self-insurance, you do agree with, as you stated. So then, to any further conversation in regards to how Port Authority or what they do is really not even needed, because we would figure that part out and go forward. That's what it is that we're talking about in the beginning. Okay, so then you don't have a problem with us moving this forward and amending it?
That is correct.
Okay, good. And that basically what it is that we're trying to get out. I do support, based on our conversation that we have had, and thank you for your input in assisting us with getting the correct bill to have that done and move forward. Thank you for the time, Mr. Chair.
Thank you so much, Senator DeGraff. Senator Francis.
Thank you very much, Mr. Chair. I, too, am in support of this measure, and I think it makes good sense in respect to having the self-insurance, especially when you have done your analysis to determine over the years that you have not had to make such a substantial payout despite having to pay all of these insurance. But insurance, of course, is a risk. Being able to protect a risk situation. And for me, I believe that's what's critical here is that while you have not seen this within the last 5 years, a next event could really wipe out the entire $200,000, even though there are events, that is, because, of course, there's a cap of $75,000 that will be able to, that will be assessed for a payout maximum. But I wanted to ask you, Attorney Fraser, is it the intent of the Port Authority to, on an annual basis, ensure that there is $200,000 that's put in the account, irregardless of whether or not there is money expended from that during the previous years?
Yes, Senator. With the assistance of the risk consultants, it is anticipated that monies will be the monies will be deposited towards the self-insurance fund in the same way as though we're paying premiums, and annually that money will continue to increase. As you just indicated, it is a risk, and we don't want to maintain a fund with just $200,000. Once we can get the fund built up to get to a level of maybe multiple millions of dollars, then the Port Authority may find itself, it may have some reprieve for a period of time. It may not have to put any more money into the fund because there's sufficient level based on the actuarial assistant analysis that is done that would provide more savings for the port.
Very well. So you don't see any difficulties in us languaging to make sure and ensure that Port Authority will be depositing $200,000 over a period of time until it gets to that level where you think is sufficient to manage the risk associated with it?
No object.
Very
no,
well.
Senator.
Thank you. And also, what about identifying the categories? I know that this is outside of the real estate and other areas. Are you aware of exactly what categories you intend to use this self-insurance for?
Yes, Senator. In section, what is in the current bill, section 1497 B, provides the area where we would, the fund would be, would cover the kind of risk that is there. As you indicated, we would not use it to cover, insurance, casualty insurance on our buildings, on our port facilities, on our airports, and all of that, because those are high risk, and as you said, you can get wiped out with one event on those. However, we have some control over things like our automobile events in liability, general liability issues, where we have the $75,000 cap, that statutory cap, that provides us a way to manage this risk. The risk coverage on when our buoys and our ocean marine markers are damaged, we have fund, we can go and replace those because we have those in place. So those are things, areas that clearly that we would manage. We're not going to provide coverage for, as indicated, medical insurance or health programs or even life insurance programs, but clearly just the items that are first party, those that are events that happen without the involvement of other persons.
Very well. And in my conclusion, in respect, and they have not been mentioned here today, in the event that the $200,000 that's on a startup, if the event takes the entire $200,000, what will happen then? What is the next mechanism by which that payout would occur?
Well, immediately, as we indicated, in the year 2021, Port Authority have an insurance premium of over some $1.2 million. It is anticipated, so insurance is now in place. By November 1, the insurance that we currently have will expire. So between now and then, Port Authority would have the means to build up the fund sufficiently to exceed $200,000, so that by November 1, we don't have to go out in the market and pay high prices in premium. We would have a fund that exceeds $200,000 very easily to satisfy the requirements that we would have for this fund.
Very well. Thank you. Thank you for your response, Attorney Fraser. Thank you, Mr. Chair, for the time.
Thank you so much, Senator Francis. Senator Fred Gregory.
Thank you, Mr. Chair. So I look at this a little differently. And I am all in favor of the Port Authority definitely being self-insured for these respective equipment, if you will, right? But I think that we are making, based on the presentation provided by the attorney, we're talking about a whole insurance program with $200,000 in it. So the minimum is $200,000, which if we're going to talk program, then that is not significant enough. And it's not significant enough because I looked at what the losses were over a 5-year period, and you have some $600,000, right? Correct?
Well, actually, the highest it has been is $300,000.
Okay, so
$600,000 is potential savings.
No, they said Virgin Islands paid premium over losses of over 600. So that's your premium. Okay, understood. So from 2018 to 2019, your losses were less than 300,000. That's a year, correct?
Yes.
And then you said that in 2020 to 21, why is that information unavailable? We are now in 2022. What are the filings?
We requested that information from our carrier, and we only have part of the year. I was not able to get the rest, and the amount
so what do you have for part of the year?
Basically, part of the year up until just from, the amount that I got was like $14,000, and I don't believe that's complete, so I didn't have available to give the accurate.
Is your items like your fireboat, etc., considered under this Self-insurance?
1 minute.
Yes, our vessels would be
Your vessels.
would be included in.
And what does it cost to replace a vessel? About $1 million?
Okay, I don't know the exact cost. But
About $1 million. So
yeah,
the concern that I have is, well, we speak to a minimum of 200,000. I think there must be some requirement that annually there is some amount that's placed within this fund. I see it as a fund where you have a restricted account where you set aside those funds, and not necessarily as a program, because I think as a program you are talking about I think I saw where you have the chief financial officer will appoint a risk manager who will carry out the day-to-day administrative duties of the program. I mean, I just don't see this. Just based on my experience, let me just be straight up. As serving as previously as a CFO at Port Authority, I just don't see the need for anyone to be designated to carry out day-to-day activities for this program per se. I see as the need arises, then the matter matter be investigated and addressed.
Time.
Oh boy, Mr. Chair.
Go ahead.
So I just see that this is asking or placing the Port Authority in more than it needs to be placed in. If it's a self-insurance program, then I think the legislation just needs to be clear that we provide the authorization for self-insurance up to X. You could start out with your 200,000, but annually there must be some sort of funds that go into it, and then once there are claims and funds are paid out, it still has to maintain a certain amount of money, and I just don't think that $200,000 is sufficient for the maintenance, because if you have your vessels included in there, your vessels are not cheap. In addition to the fact of this also deals with not the actual property, but also the insurance around any medical issues that may arise out of the accident, if you will, correct?
For third parties.
Third parties and the individual, and the individuals operating the Port Authority's equipment.
Well, Port Authority employees are covered under the workman compensation provisions of the law. And for third parties, we have the 75% statutory cap that would cover that. So regardless of what medical expenses may incur, we will never pay out to any individual more than $75,000.
That presents a little problem for me, especially when we're talking about our vessels. I mean, I could understand the bullards and those types of things. I get that. But when we begin to talk about our vessels, we need to drill down on this a little further. You're saying an employee driving out a vessel, an accident occurs, they deal with their work. Their coverage is tied to workmen's compensation alone?
Yes.
There could be loss of life. So how do we address that?
That's covered, as long as it's a Port Authority employee, it's covered under the workman compensation law. Now, our experience, and that's one of the reasons why I say, Senator, that we refer to it as a program, because the deposits that would be made to the insurance fund, these would be determined on an actuarial basis with the assistance of our risk management consultants to make sure that Port Authority is properly funding it rather than having it done on a, in an arbitrary way. But your concern is correct. You want to make sure that, you don't just try to have this available for $200,000, because if you get, 5 maximum liability events in 1 year, that can certainly wipe out your $200,000 fund.
Absolutely.
But responsibility would be for the Port Authority to make sure that it fund the program sufficiently to make sure that the projections out for the year and assumptions are accurate and continue to grow that insurance, the self-insurance fund that is dedicated to cover this.
Okay, so I just think that we need to have a little further discussion around this, around the difference between program and fund. I think that's a very big difference. So we need to be clear on what it is that we are saying yes to when it comes to moving this forward. My time has been called, so I have to return my conversation to the chair, but I do have some concerns around those types of vessels, particularly, you know, the vehicles is one thing, but when we start talking about the vessels, that presents a different conversation for me. Thank you, Mr. Chair.
Thank you so much. And the vessels range in price from $300,000 to 1.1 for the law enforcement vessels that they utilize. In speaking to the Port Authority, the intent isn't to leave it at 200,000. The intent is to continue to make that $200,000 capitalization every single year so that they could build up that particular funding balance. But we will have an opportunity, colleagues, to the burning questions that we have. We know the areas that we need to change to make the bill amenable to be able to move on. So any other areas we have in terms of whether we utilize the word fund or program, I can see both being used, fund in certain instances and program in the next instance, but I will definitely go over all the items in the bill and make sure that we make the changes that are necessary to move this forward. Senator James, you recognize.
Thank you, Chairman, for the time. I was reading Title 22, Virgin Islands Code, Section 1485, and there's a section that speaks to each member shall have a contingent assessment liability for payment of actual losses and expenses occurred while this policy is was enforced. So my question to the Port Authority, as far as any assessment or evaluation that have been done prior to this legislation coming down, have you been able to do that when it comes to the risk involved?
Yeah.
Number 4.
Senator, the idea when we started talking about doing the research on this bill, the idea was that while we have a 200 the fund that you're referring to, this $200,000 was taking the place of that. It was anticipated that by the presentation that is made to the Commissioner of Insurance, that he would be an independent voice that determines if the Port Authority is properly funding this fund from which claims would have to be paid. And that we would provide him the claims experience, we would be provided with our projections, and that would be determined independently. Because as I said, it is not something that would be arbitrarily determined, but there will be a scientific or mathematical means by which we determine how to make deposits to that fund. So this $100,000 was doing the same thing that you're referring to in that section of 1485.
1 minute.
Thank you. And in your testimony, you made mention that in 2021, VIPA paid a specific amount for premiums for the same coverage, and then you mentioned how much you paid for fiscal year 2022, how much we're about to pay. My question is, you mentioned the cost saving, which is good, but what has been the greatest loss ever received or experienced by Virgin Islands Port Authority? And I know you probably said during a hurricane, right?
Well, the Hurricane Port Authority suffered substantial everything. But most of those kinds of, the losses during that time would not have been covered by a self-insurance program, because those losses primarily with our buildings and our facilities would be in a different category, which will not be included as part of this program. Year to year, the amounts that we pay out, I think we probably pay more in claims in automobile accidents more than anything else.
Time.
Okay, and thank you for that clarification, and Mr. Chair, with your indulgence. You said in 2018 to 2019 policy year, Viper had losses that were less than 50% of the premium cost, and you said those losses were less than $300,000. Can you speak to directly to what triggered those losses, or was that the same thing that you just made mention of?
Yeah, they would be primarily our biggest loss category is in automobile losses, where we have to pay out to third parties when employee staff may get in an accident. You have to fix people's car, people personal injury. Those are the biggest drivers of the events, the claims that we receive in any given year.
And I would just end by saying, hold your employees accountable when it comes to taking care of the government and the Virgin Islands vehicle.
Yeah.
Thank you.
We do that. We do that. We also have defensive driving training that employees are required to go through every year, and it has been our practice last couple of years.
Okay, thank you. You seem like you're sticking. I don't want to abuse my time, but please, drivers, take care of the government's vehicle. Thank you, Mr. Chair, for the time.
Thank you so much, Senator James. Senator Sarro.
Thank you, Mr. Chair. Good afternoon again. Attorney Fraser, how are you this afternoon?
I'm fine. Good afternoon, Senator Sarro.
Curious, just tell me, how many vessels do you have now at the port?
I'm sorry, I don't have that. I'm thinking it's less than 10. We have 3, 2, somewhere between 5 and 10.
Okay.
They're primarily used for the pilot vessels. In St. Thomas and St. Croix, we have pilot, and I think we have 1 or 2 police vessels as well.
Okay. Attorney Attorney Richards?
Yes.
So in your testimony, and I understand that amendments will come, but on page 5, when you said that the Section 1497 of the proposed bill, which sets out the insurable assets that would fall within the scope of the Virgin Islands Port Authority self-insurance program, is potentially overbroad. Can you explain that for me, please?
Okay, the reason that was stated is because the proposed bill as written specifically sets out in Section 1497A the assets what would not be included in the self-insurance program. So Section 1497A states that the Port Authority may not seek to self-insure the first-party property aspects of its real property assets and the improvement thereon and the employee medical and health program. Section 1497B then goes on to list the things that would be covered under the self-insurance program, and there's one section, the last one, that says any other risk that is not excluded by this section. So if something isn't...
It's like a catch-all phrase.
Exactly. And if something isn't excluded, then it's potentially included. And that's why the issue was raised, at least with respect to life, because medical and health are generally not considered to be life insurance. And so the failure to specifically exclude it might raise the potential that it could be included. So
1 minute.
Okay. No, let's go quickly to So page 4, about the bill lacking any enforcement mechanism, and then in the testimony from Attorney Fraser on page 6, he says the VIPO will be required to comply with the regulations and orders of the insurance commissioner pursuant to Title 22, VIC Chapter 58. And then here we have in your testimony that the bill lacks any enforcement. If this is to go through, who's the enforcer?
Well, it's a self-insurance program, and self-insurance is generally not regulated. So any self-insurance program.
How it's written.
What, I guess.
So the concern, and I'm sorry.
Yeah.
What I was asking, if you can answer briefly, so how it's written right now is that you have that it appears to lack any enforcement mechanism. So go ahead, finish your statement.
Okay.
That's my confusion there.
Okay. The proposed bill. Generally, in the business of insurance.
Mr. Chair.
You may
Mr.
proceed.
Chair, can I conclude?
Go ahead and proceed.
Okay. Well, generally in the business of insurance, we generally have an enforcement mechanism. We wouldn't just issue, renew, or refuse a certificate of authority. We would have the ability to suspend or to revoke it, and even to issue a cease and desist. So the bill is written, and that's probably because it's a government entity, and we don't regulate government entities. Doesn't really allow any enforcement mechanism, just as written and presented here today. So it's different in that regard. And even the regulations, it should be noted that, the bill as written would only subject the VI Port Authority to the regulations of the commissioner to the extent considered reasonably necessary to protect the Port Authority and the public interest. The Port Authority, as a government instrumentality, would, under the bill, have their own authority to issue their own regulations. And at least the way the bill is currently drafted, the management of the self-insurance program under Section 1498 would be the governing board, would be the responsibility of the governing board of the Port Authority. They would have the general oversight over this program.
So I wanted to put on the record that when you highlighted that there's no enforcer, that's because you don't really enforce a government entity, and that would be the duty of the board. That's what I wanted to clarify on the record.
Yes, generally, we don't regulate government entities, and in this case, for the Port Authority, it would be the governing board of the Port Authority.
Perfect. Thank you, Mr. Chair, for the latitude.
Thank you, Senator Sarro. And in where you had maintenance of certificate, we're going to change that to maintenance of self-insurance. And that is where we can put in some of what you're speaking about, and some is already contained in that particular section: maintenance of a risk management program, maintenance of a deposit of cash and securities in the amount of $200,000, maintenance of excess insurance in accordance with sound actuarial principles. So there are a number of items in there that are protection for the self-insurance program as prescribed or pursuant to the authorization under the Port Authority. That's why we just don't want to give the authorization alone. We want to make sure that, and the Port Authority worked on this bill, that in fact what they sent down, and that would be able to regulate and monitor the program, is included, but it's just not included under the Lieutenant Governor office, but directly under the authority. So where you see Commissioner, that will be the program administrator, which is the Chief Financial Officer for the Port Authority. Senator Joseph, you still there? Okay, I think that is a no. Okay, so I think we have exhausted all testimony. We had a very good earlier meeting in reference to this particular measure and what we need to do. I want to thank Attorney Fraser and Attorney Matthew and Attorney Richards and also Mr. Bertrand, who has been here all day, for coming to the legislature and providing testimony on these two bills. Colleagues, we are going to vote in 1 minute. Let me recess so that we can be able to vote. This committee stands in recess for 1 minute. Committee of Finance is back on the record. Before we go to the motion, we will be amending this bill with all the various recommendations that we heard and with some further discussion. So at the next level, we will have an amendment in the nature of a substitute to make sure that we cover all of the areas and we have a fresh bill. Do I hear a motion? Motion, Senator Fred Gregory.
Thank you, Mr. Chair. I move that Bill number 34-0204, an act amending the Virgin Islands Code, Title 22, Chapter 58, relating to self-insurance, and Title 29, Chapter 10, Section 543, relating to the powers of the Port Authority to authorize the Virgin Islands Port Authority to establish a self-insurance program to cover and manage certain risks, be favorably voted on in this committee and forwarded to the Rules Committee for further consideration and action. I so move.
Thank you. Motion made by Senator Fred Gregory, seconded by Senator James. Roll call.
Senator Marvin A. Blyden. Senator Blyden, absent. Senator Samuel Carrion. Senator Carrion, yea. Senator Dwayne M. DeGraff. Senator DeGraff, yea. Senator Donna A. Fred Gregory. Senator Fred Gregory, yea. Senator Javon E. James Sr. Senator James Sr., yea. Senator Janelle K. Saru.
Yes.
Senator Saru, yea. Senator Kurt A. Vialet.
Yes.
Senator Vialet, yea. Mr. Chair, you have 6 yeas, 1 absent.
Thank you. Thank you, Madam Clerk. Bill number 34-0204, an act amending the Virgin Islands Code, Title 22, Chapter 58, relating to self-insurance, and Title 29, Chapter 10, Section 543, relating to the powers of the Port Authority to authorize the Virgin Islands Port Authority to establish a self-insurance program to cover and manage certain risks, has received a favorable vote in this committee and will be sent to the Committee of Rules and Judiciary for further consideration. Colleagues, today is a short day. I want to thank you for your participation. I want to thank the testifiers for being here and thank my staff along with everybody else, media security, all the central staff of the legislature. The Committee of Finance is hereby adjourned.